have breaking news from the federal judge overseeing the case involving deportation flights to El Salvador. U.S. District Judge James Boasberg says he found probable cause to hold the Trump administration in criminal contempt. The judge says it's for violating his orders to turn around those planes that were carrying migrants to El Salvador. So let's bring in CBS News Department of Justice reporter Jake Rosen for much more on this. Jake, what can you tell us? What have you learned?
Well, in Judge Boasberg's scathing 40-plus page memo, he writes, "The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it." The order at the center of this came on March 15th when Judge James Boasberg, after blocking the deportation temporarily of 5 men, expanded that block of people who the Trump administration was attempting to deport under the Alien Enemies Act.
Hey everybody, Adam is here. So what's happening right now, Trump has reached that moment where every escape route he's relied on has been studied, countered, and shut down. The playbook that worked every time before doesn't work anymore, and what's coming is actually coming. For Donald Trump, that moment arrived on March 19, 2026.
On Friday, an unsealed ruling by federal Judge James Boasberg said the subpoenas sent to the Federal Reserve were designed as a pressure campaign against Fed Chair Jerome Powell. In his blistering decision, Judge Boasberg wrote, "There is abundant evidence that the subpoena's dominant, if not sole, purpose is to harass and pressure Powell, either to yield to the president or to resign and make way for a Fed chair who will." In his order, Boasberg pointed to at least 100 statements by President Trump or administration officials attacking Powell. The president has often sparred with Powell and has criticized the Fed chairman for not quickly slashing interest rates.
Too late. I call him Too Late Powell because he's always too late. She's like just a stupid person.
It did not arrive with a dramatic arrest. It did not arrive with cameras flashing and handcuffs clicking. It arrived with a single federal judge in Washington, D.C., issuing a warning so clear, so direct, and so backed by institutional authority that the response was not a counterattack, not a fundraising email, not a rallying cry to the base. The response was silence. The response was deleted posts. The response was a lockdown at Mar-a-Lago and Secret Service agents quietly preparing extraction protocols.
There's enough evidence to hold Trump administration officials in criminal contempt over deportation flights. That's the decision from a federal judge. And tonight, the White House is vowing to appeal.
Hey, Kenneth. Back on March 15th, D.C. Judge James Boasberg told Trump administration officials anyone on the planes that were bound to El Salvador, the deportation flights, even if those planes were in the air, had to be returned to the United States. But that didn't happen. According to the court, those planes touched down briefly in Honduras before continuing on to El Salvador, where those individuals were transferred to a Salvadoran mega prison. And now Boasberg says that there's enough evidence based on what was happening behind the scenes to hold Trump officials in criminal contempt.
Judge James Boasberg, one of the most significant federal judges in the District of Columbia, looked at the pattern of public threats and defiant statements and said no more. Continued defiance, he warned, equals contempt and detention pending trial. Not fines, not warnings, not more chances. Detention, physical custody, handcuffs, a cell. And on the same day, the House impeachment vote was moving forward. The same day, a 112-page criminal referral demanding mandatory post-conviction custody landed on the federal docket. The same day, 25th Amendment odds hit 65% and Senate conviction odds climbed to 87%. And within hours of Boasberg's warning hitting the public record, Trump deleted the Truth Social post attacking the prosecutor. He deleted it. The man who has never backed down from anything, who has turned every attack into a counterattack, who has treated every legal threat as a fundraising opportunity, deleted his post. Do you understand what that means? When Trump deletes posts, something is fundamentally different. The normal response is to double down. The normal response is to attack harder, go louder, turn the volume up to 11, and let the bass carry the message. The normal response is not to go quiet and erase what you already said, and yet that is exactly what happened. Let me walk you through what Boasberg actually did, why it landed so differently from every other legal warning Trump has received, and what the operational preparations happening right now tell us about where this is going. To understand why Boasberg's warning is different from every legal threat Trump has faced before, you have to understand what it removes. Up until this moment, Trump has had one remaining tool that has worked through every other crisis: the Truth Social offensive, the public pressure campaign, the attack the prosecutor playbook that generates clips, rallies the base, and creates enough political noise to muddy the legal waters, to give judges an excuse to delay, to give attorneys a narrative to use in filings. That tool has been working in various forms for years. It has been the constant companion to every legal proceeding Trump has faced. The parallel public campaign that complicates the legal process by turning every courtroom into a political battlefield. It has been effective. It has delayed outcomes. It has created uncertainty. It has given Trump something to do while his lawyers filed motions. Boasberg just shut it down with a federal order backed by contempt authority and backed by detention authority. The next Truth Social post attacking prosecutors, the next public threat, the next attempt to use the media environment as a legal delay mechanism, results in immediate contempt proceedings and detention pending trial. Not a fine, not a warning. Detention. And Trump deleted his post within hours, which means the warning worked. Which means the last remaining tool in the playbook has been neutralized by a federal judge with a one-paragraph order. When the playbook is gone, when every tool has been removed, when the posts are deleted and Mar-a-Lago is in lockdown and DC Marshals are mobilizing, what you are watching is not a political crisis anymore. What you are watching is a man running out of road in real time with a court date 3 days away. Now let me walk you through the full legal architecture that Boasberg's order sits inside, because the gag warning is the headline, but the structure underneath it is what makes the outcome unavoidable. Federal judges in the District of Columbia have broad contempt authority in cases before their court. That authority includes both civil contempt, which typically involves fines and compliance orders, and criminal contempt, which can result in detention. Boasberg did not threaten civil contempt. He threatened detention pending trial. That is the criminal contempt track. That is the track that results in a person being held in federal custody, not fined, held until the underlying contempt issue is resolved before the bench. And for that contempt threat to apply, all that needs to happen is one more public attack on prosecutors connected to this case. One post, one statement, one interview that crosses the line Boasberg has now drawn publicly, and Trump deleted his post, which tells you that the legal team communicated to him clearly that Boasberg means it, that this is not a warning designed for negotiation, that the next post results in the next step, and the next step is detention. Before the impeachment conviction even happens, before the March 22nd hearing, detention pending trial in a federal facility on the authority of the federal judge overseeing the case. Now let me show you how Boasberg's order coordinates with the criminal referral filed by the Graves investigation, because the explicit coordination between these two federal actions is the most legally significant structural element of everything that has happened this week. Graves filed 112 pages demanding mandatory post-removal custody. Boasberg issued a gag and arrest warning on the same day. Those two actions are not coincidental. They are coordinated, and the coordination is visible in the language. Boasberg's warning references continued defiance on DOJ perjury about Iran war costs, which is specifically one of the 3 charges in the Graves filing. Graves mentions the Boasberg contempt mandate as a supporting pillar of the mandatory custody argument. These two federal authorities are referencing each other's actions explicitly. They are operating as parts of the same legal system rather than as independent parallel proceedings. And then there is Judge Chutkan, whose removal signal we covered earlier. Chutkan's document is also explicitly cited in the Graves coordination language. 3 federal legal authorities, Graves, Boasberg, Chutkan, all referencing each other, all moving on the same timeline, all aimed at the same legal outcome, mandatory post-removal custody following impeachment conviction. That 3-point coordination is what closes off the legal exits that would otherwise be available. Because when you have a single legal proceeding, a single judge, a single prosecutor, a defendant with enough resources and enough legal talent can find procedural pathways to delay, to challenge, to appeal, to create the kind of legal uncertainty that stretches outcomes into months or years. That is how high-stakes federal cases have historically been managed by well-resourced defendants. But when three separate federal authorities are operating in explicit documented coordination, each one referencing the others, each one providing independent legal support for the same outcome, the procedural pathways narrow dramatically. You cannot successfully challenge three coordinated federal authorities simultaneously using the same appellate strategy you would use against a single proceeding. Now let me tell you about what is happening at Mar-a-Lago and what it tells us about how the people closest to this situation are reading it. Secret Service does not prep extraction protocols as a precaution. They do not run logistics on physical custody scenarios as a theoretical exercise. When the Secret Service is preparing extraction protocols in coordination with D.C. Marshals, that preparation reflects an operational assessment that a specific outcome is imminent and requires advanced planning. And the fact that this preparation is happening and is being reported tells you that the people whose entire professional responsibility is to accurately assess and prepare for real physical outcomes have made a determination that the post-conviction custody scenario is not hypothetical. It is operational. It requires logistics. It requires coordination between the protective detail and the federal marshals who would be responsible for custody transfer. D.C. Marshals mobilizing in coordination with the post-impeachment timeline is the federal law enforcement component of that same operational picture. Marshals mobilize when a custody transfer is being planned, not when one is being discussed in the abstract, when one is being planned in specific operational terms. And the coordination with the impeachment timeline means the mobilization is keyed to a specific trigger, the House vote, not to a general possibility. The predicted jail odds moving from 65% after the Graves filing to 68% after the Boasberg warning is a smaller movement than some of the jumps we have tracked this week. But the direction and the timing tell the story. Those markets moved up, not down, in response to Boasberg's order, meaning the legal and political community read the gag and arrest warning as making the custody outcome more likely, not less. And the deleted Trump posts are being priced into those markets as the most significant behavioral signal yet, because they represent the first time the administration's public response pattern has visibly changed in direct response to a judicial order. Now let me connect all of this to the full picture, because the Boasberg story does not exist separately from everything else, and the connections are what give it its full weight. The Supreme Court immunity denial removed the constitutional shield. The Graves filing walked through the open door with 112 pages and 18 exhibits. And the Boasberg warning neutralized the last remaining tactical tool, the public pressure campaign that could have complicated the legal process by generating political noise. With all three of those elements in place simultaneously, the immunity gone, the criminal referral filed, the public pressure tool shut down, the legal path to custody is cleaner and more direct than it has been at any point in this entire crisis. The 87% Senate conviction odds, up from 85% before the Boasberg order, reflect the market read that the judicial escalation makes the Senate conviction not just politically likely but judicially consequential in a way that changes the calculus for the final holdout Republican senators. Because those senators are now looking at a situation where conviction does not just mean removal from office. It means the transfer of a former president to federal custody with D.C. Marshals mobilized, with a court hearing scheduled, with 68% jail odds in the markets. That is a different vote than a conviction that results only in political removal. That is a vote with a much more concrete and visible downstream consequence. And for senators who were on the fence, that concreteness is one more weight on the scale. The 25th Amendment odds at 65% with cabinet secretaries wavering are now being evaluated against the same backdrop. Cabinet members considering Section 4 are now looking at a situation where the president they would be removing is facing simultaneously a gag order, a criminal referral demanding mandatory custody, a federal court date in 3 days, 68% jail odds, mobilized DC Marshals, and Secret Service extraction protocol preparation. That is not an abstraction. That is an operational picture. And cabinet members making the most consequential decision of their careers are now making it against that specific operational backdrop. Let me break this down into the 3 points that tell you exactly where we are. Point 1. The gag order neutralized the last tool in the playbook, and the deleted post proves it worked. Every legal crisis Trump has faced has been accompanied by a parallel public pressure campaign that complicated the legal process. The Truth Social attacks on prosecutors generated political noise. The base rallied. The media covered the political conflict rather than the legal substance. Attorneys used the public environment to argue bias and political persecution. That parallel campaign has been a deliberate and effective tool. It has worked for years in multiple jurisdictions. Boasberg just ended it with a single order backed by detention authority. And the proof that the order worked, the proof that this time is different from every other time a legal warning has been issued, is the deleted post. Trump deleted the post attacking Graves. That is the behavioral signal that no amount of public statement or surrogate explanation can reframe. He deleted it because the legal team told him the next post results in detention pending trial. And for the first time, the response was compliance rather than escalation. When the playbook's last tool is neutralized, when the parallel public pressure campaign that has protected the legal strategy for years is shut down by a judicial order that actually produced compliance, you are no longer looking at a managed legal crisis. You are looking at a defendant who has run out of moves, and the DC Marshals mobilizing, the Mar-a-Lago lockdown, the Secret Service extraction prep, are the operational confirmation that the people responsible for planning what comes next have reached the same conclusion. Point 2. 3 coordinated federal authorities moving on the same timeline close off the procedural exits that would otherwise be available. A single federal proceeding, even a serious one, can be challenged procedurally in ways that create delay and uncertainty. A skilled legal team with enough resources can find the appellate angles, the venue challenges, the jurisdictional questions, the evidentiary disputes that stretch a single case across months or years. That is the traditional high-stakes federal defense playbook. But Graves, Boasberg, and Chutkan are 3 separate federal authorities operating in explicit documented coordination. Each one is referencing the others in their filings and orders. Each one is providing independent legal support for the same outcome. Each one is on a coordinated timeline keyed to the impeachment vote and the court hearing. A challenge to the Graves filing does not affect Boasberg's contempt authority. A challenge to Boasberg's order does not affect Chutkan's removal signal. A challenge to Chutkan's document does not affect the Graves criminal referral. Each one stands independently while reinforcing the others, and challenging all 3 simultaneously in 3 separate appellate tracks, while a Senate trial is moving at 87% conviction odds and DC Marshals are mobilized, is not a viable legal strategy. It is a description of a legal position with no viable exit. Point 3. The 68% jail odds combined with mobilized marshals means the operational picture has moved from projection to preparation. All week we have been tracking probability numbers. Conviction odds, 25th Amendment odds, jail odds. Those numbers are projections. They reflect the aggregated judgment of analysts and markets about the likelihood of specific outcomes. They are informative and significant, but they are projections. Mobilized DC Marshals are not a projection. Secret Service extraction protocol. Preparation is not a projection. Those are operational preparations for a specific physical outcome that the people responsible for planning have assessed as imminent enough to require advanced logistical work. You do not mobilize marshals as a hypothetical exercise. You mobilize marshals when you are planning a custody transfer and you need to work out the operational details in advance. And the coordination with the impeachment timeline means the mobilization is keyed to a specific trigger on a specific date. The 68% jail odds moving up after the Boasberg warning, not down, confirms that the legal and political community is reading the operational signals the same way the operational people are reading them. The marshals, the extraction prep, The deleted post, the Mar-a-Lago lockdown, the court hearing, the conviction odds, the 25th Amendment probability, all of those signals are pointing in the same direction. And the markets are pricing them at 68% and still moving. So here is the complete picture of where we are right now. A federal gag and arrest warning from Judge Boasberg. No more public threats. Continued defiance equals contempt and detention pending trial. Deleted Truth social posts calling Graves an Iran agent, gone within hours of the warning. Mar-a-Lago in lockdown with Secret Service prepping extraction protocols. D.C. Marshals mobilized in coordination with the impeachment timeline. Predicted jail odds at 68% and still moving upward. A federal court hearing 3 days away. A 112-page criminal referral with 18 exhibits demanding mandatory post-removal custody. 3 coordinated federal authorities. Graves, Boasberg, Chutkan, operating as an explicitly documented system. Senate conviction odds at 87%. 25th Amendment odds at 65% with cabinet secretaries wavering. A House impeachment vote already on the permanent record. All of it building. All of it connected. All of it moving toward a 72-hour window that has a court date, mobilized marshals, and 68% odds attached to it. The gag order shut down the last tool. The deleted post confirmed it worked. The marshals are mobilized. The extraction protocols are being prepped. The court hearing is 3 days away. This is not a projection anymore. This is a preparation. And preparations have timelines. And this one is 72 hours. Watch this space. Because Wednesday morning in a federal courtroom in Washington, D.C., the next chapter of this story begins. And it begins with a man who has run out of moves, who has deleted his posts, whose last tool has been neutralized, who is staring at mobilized marshals and a court date he cannot delay, and for the first time in his life, he has nowhere left to go.